they are not serious, parties agree.
Can you give us examples and how you apply the ADR in criminal cases?
Okay, cases like assault, parties can agree, talk among themselves and agree to settle the matter out of court. And once they have agreed, then they come to court to inform the court, and then the reconciliation can be recorded. For
then what happens?
Sorry?
Just give us the procedure, how we apply ADR in criminal cases, how you have applied ADR in criminal cases. Because the persons, the party, the what is before you is a charge sheet, isn't it?
Yes.
And an accused person. So how have you been applying ADR in such cases? It's an assault case.
Okay. Most of the time, these people talk out of court, and they come to say that we have agreed, and they talk to the prosecutor withdraws the case.
And if the complainant is a child?
If the complainant is a child, I have to consider the interest of the child. Because the person who has been, the person affected, the person who has suffered is the child. I cannot allow unless it depends on the offense. A very serious offense against a child, I cannot allow. And even the other offenses, for children, they do not have the capacity to consent to an agreement.
So apart from assault, which other cases have you applied? Apart from assault, which other cases?
For murder, there is still ADR, but done by the parties on their own.
Murder?
For murder, it's not they are not referred, but they go through some processes in the community, and then they come to the prosecution to request for plea bargain. So by the time they are coming to request for plea bargain, they've already settled, they've already done the cleansing in the community. So that is what is happening in most of the murder cases. Most of the cases which go through plea bargain. By the time they are coming to court already, the parties have agreed, they've done the cleansing through in their cultural way. And then the prosecutor now is
informed. In murder cases, the complainant is the Republic, and the deceased has no capacity to enter into any agreement with anybody.
Okay, the complainant is the Republic, and that is why the prosecutor is involved, and they cannot be allowed to enter into plea bargain without the consent of the prosecutor. It is the prosecutor who is running the process. But by the time they are coming to court, they've already done their own processes in the community. That is what happens in most of the murder cases.
Don't you think that is serious? That we settle most of murder cases through ADR? Okay,
it does not mean this person. It does not mean this person will be released.
The accused person is not there to speak for himself.
Okay.
Sometimes the accused person, let's say for example, the accused person is Luo, the wife is Kalenjin, the mother is maybe coming from the coast. They profess 3 different faiths. Which community values or culture would apply?
Okay, from my experience, these processes happen within the same community, and you will find them, people within the same, maybe family or neighbors. And in most cases, you will find offenses which, they are charged with murder, but the ingredients look like the manslaughter in most cases. They are not planned murder, and they agree among themselves, they reconcile, but the court is not bound in most cases, the court is not bound to impose the sentence that they may be
What is your
expecting.
view? What is your view of the applicability of ADR in murder cases? You are now your view as a judge.
Okay, my view.
And if you'd be elevated to the Court of Appeal, you are confronted with such a matter where there is ADR has been applied in a matter by the parents, but the spouse, if it is a husband, is disagreeable.
For murder cases, they cannot go through plea bargain unless the prosecution are involved. For it to, most of these processes happen without the knowledge of the court. By the time they are coming to court, they've already happened. But in most cases, the consent.
But plea bargain is not ADR as such, because in plea bargain, there is a charge sheet and somebody actually pleads guilty to an offense and is convicted.
It may not be ADR, but the process that has gone on in the community is ADR before it comes to plea bargain. So I may not call it plea bargain, ADR, but the process that goes on before the matter comes to court, now to go through the process of plea bargain, is AJS, not.
So what is alternative to what? Because it is AJS is alternative justice system. Mm-hmm. So what is alternative to what?
It is alternative to the formal court process.
And there is a hybrid.
Yes.
According to what you're saying.
It is true. Yes.
Let's leave it there. Thank you.
Okay.
Thank you, Honorable Chair. Judge, one or two questions from me. A period of 32 years in the judiciary, is that to say the judiciary has been your only employer ever since you left college?
I was an advocate for 1.5 years before joining the judiciary.
1.5 years, and then you joined the judiciary?
Yes.
All right.
Yes.
Now, this morning, part of the discourse has been on mandatory sentences. And I'd like to paint to you a scenario that is very common in our courts. The Sexual Offences Act, you have a young man of 19 years old. He has filed an appeal which has come before you as a judge. He impregnated a 17-year-old girl, and the girl has given birth. This girl, together with the child, are staying at the boy's place. The young man is in custody behind bars, and whenever the case comes up for mention, for directions, or for the hearing of the appeal, this lady comes to court to see what is going to transpire on that date. At the end of the day, she goes back home to her mother-in-law, as it were, and the mother-in-law, of course, is under then an obligation to see that they raise the child together. The child, of course, on the other hand, is being raised up in the absence of the father, who is in custody. Now, the young man has been sentenced to life imprisonment. How will you handle this appeal? It is not denied, of course. He made her pregnant. That is why there is a child who was born. But now here is a question of sentence.
Okay, first I will look at what the Constitution says about the case, circumstances of that case, and then the statute. The statute has a minimum sentence.
Yes.
And the Supreme Court has clarified
that
we should not go below the minimum sentences, but we can impose above. The discretion is on any other sentence above the minimum. So I'll be bound by the statute. I may want to sympathize with this family because there is an interest of the child, but because of the legal provision, then I will not. I will not release the boy, but I may make recommendations for enactment of policy on how to deal with such cases.
How? What will you be saying in
I'm
your
imagining there could be another way of coming up with a policy or maybe legislation on how to deal with the...
I am sure you've come across such a scenario. Or near a similar scenario.
Yes.
In the course of your work as a magistrate stroke a judge?
Okay. With the
Is there a problem in the justice system?
There is a problem. In my view, this young man should be released because the interest of the child, there's also the interest of the child,
So
which should be
the
taken
young
care
man
of.
is before you.
It's before me, but I'm also bound by the provision of the law.
Okay.
I have to balance the interest of the child and also the
But you are
statutory
saying
provision.
that you would make recommendations.
I will make recommendations for
Have
this
you
the issue
had-
to be addressed.
Have you had an opportunity to make those recommendations?
Okay, I've not done now, but if confronted with such a situation, maybe I'll make recommendations.
So you're saying you've never handled a case that is near similar to that one?
I cannot recall now.
Okay.
Yes.
But of course, when the Sexual Offences Act was enacted, was it meant to cater for situations like that, what we commonly refer to as Romeo and Juliet?
Maybe there was not much consideration, and but we can still have a debate on how it should be addressed.
All right. Now, let's assume you've been successful in this interview and you are now in the Court of Appeal. And last week we talked quite a lot about 52B applications. Again, I want to give you a scenario and you tell us if a draft was brought to you and the draft is reading partially, this is what is reading. On arguability, we find that the applicant has demonstrated that he has an arguable appeal, as it is clear that the High Court erred in granting the respondent an order of permanent injunction to restrain the applicant from trespassing onto his land. I can repeat.
Yes.
On arguability, we find that the applicant has demonstrated that he has an arguable appeal, as it is clear that the High Court erred in coming to the conclusion that the respondent had established a case for the issuance of an order of permanent injunction.
Okay, in my view, okay, this was an application.
Yes, an application
But
of
it is-
52B.
But it is giving final orders. I thought, in
No,
my view,
no.
that should have been considered in the main appeal.
The final orders were given by the High Court at the end of the trial.
Yes.
You know, even at the High Court, I mean, even if it comes to injunctions, you can seek for an order of permanent injunction. So that prayer for permanent injunction was issued at the High Court level. And the applicant lost the case. And now he has come to the Court of Appeal, or she has come to the Court of Appeal, and the Court of Appeal is saying, we are satisfied that the High Court was wrong.
Okay. If you can repeat the question now.
Now the question is, so this draft has come to you with this paragraph reading the way I have read out. Is there anything wrong with it, or would you append your signature in granting the order for stay, or?
Okay, the way I'm looking at what you have stated is
Yes.
like I'll be giving final orders in an application. Yet we have not considered the appeal. We are determining that the High Court erred in making the determination, yet the appeal has not been heard.
You are actually very right in that when it comes to applications, what are those conditions? What is it stated as regards a ruling at this point? When it comes to what you've said, final orders.
I think the court should restrain itself from dealing with the issues which should be left for the main appeal.
Why should the court restrain itself?
If the court does not do that, then there will be no appeal to hear. You'll have made up your mind on the matter. Yet you've not given the
All
the
right.
parties an opportunity to argue the case.
So it's kind of like you would have determined the appeal, and you will embarrass the court that is going to subsequently hear the appeal.
Yes, true.
Thank you.
Yeah, just a follow-up from what Justice Ichale has asked. Judge, did I hear you say that the direction of the Supreme Court is with respect to only mandatory sentences? Or would that apply in all? Is there discretion in other situations whereby a judge can say exercise compassion and mercy?
The one for criminal cases?
Yes.
The directions, the Supreme Court clarified that it referred to murder cases only,
Yes.
and on the mandatory nature, not the death sentence itself.
Okay.
Yes, the mandatory, so that the courts have the opportunity to, not the court, the person has an opportunity to be heard on mitigation.
Okay.
The court has discretion to consider mitigation.
Now, in again one of the recent debates that I've seen, a judge has said that that where you are sentencing a mother who has children, who has very young children who are breastfeeding, or a mother who's pregnant, unless it's something that's so grievous, the court should elect or should give non-custodial, is it non-custodial? Sentences, so that the child does not suffer in being imprisoned with the mother. I don't know what your view is about that. Mm-hmm. Would that be one of the cases whereby, for instance, Muruatetu and the decisions that follow would be applicable?
I think so, because it's like you have to consider the interest of this child who is yet to be born.
Yes, either the mother says 8 or 7 months pregnant, mm-hmm. and the sentence says for 5 years from the maybe some misdemeanor or something like that, or it's a very, very young child, a child who's still breastfeeding, and the effect of your sentence is that this child goes to prison together with the mother. Is that something that should play in your mind even as you exercise your discretion? Or would you say that you are bound by Muruatetu and the decisions that follow, and therefore your hands are tied?
Okay, are you referring to murder?
No. I'm very clear, it's not murder.
Not murder.
Yes, where there are no mandatory sentence, where there is no mandatory sentence, where it's either not, it's not murder, and it does not involve
if
the SOA.
No mandatory, if it is not mandatory, then yes, I'll consider the circumstances of the case and decide on which kind of sentence would be proportionate.
Okay.
Yes.
So would it be proportionate for you, for instance, in cases where it's not murder, or for instance it's manslaughter, that the child should go in, the mother should go in together with the child?
It will not be.
Sorry, you're not very clear.
Yeah. Sorry?
Say it's manslaughter.
Mm-hmm.
And then you've looked at all the circumstances, and then there is this very young child. What would be your view about sending the mother to prison, or giving the alternative that they serve a non-custodial?
I think I'll have to consider the circumstances of the offense also, because you have to balance between the accused and the accused, the complainant, and the child. So the way I'll deal with it will depend on the circumstances of that particular case.
So if you have to now look at the accused, the complainant, and the child, and then you have to consider the best interest of the child, what would weigh more on you?
I cannot give a definite answer now because I have to balance.
Okay, thank you.
Yes.
All right.
Yes, Judge, you've told us that you sit on the NCHA, Committee on Criminal Justice Reforms.
I'm not sitting now, but up to the end of last year.
Up to the end of last year, yes. And that you had made recommendations,
yes,
on the Penal Code and the Criminal Procedure Code.
Yes.
Had you made any recommendations on the Sexual Offences Act, which is also a criminal law?
I remember murder, but I remember murder cases. We proposed to cascade the offense so that we can have first degree and second degree murder. Same to
So
robbery
sexual
and
offences,
violence.
you did not
I
look
cannot
at?
recall the provision now, but we changed some terms which were not complying with the requirement of the Constitution.
Okay,
Yes.
thank you. When ought a court use a structural interdict? And can you give us an example of a matter in where a structural interdict has been used?
An example of the case where structural interdicts have been used is the case of Mitubel. When this happens when in a situation where there is a gap, there is action which should be done by the other arm of government. So it is a way of the judiciary asserting itself on the issue that is before the court, because the other arm of government is not acting.
It is like supervising the implementation of the order.
Supervising, but with limitation.
Okay,
Yes.
thank you very much, Judge.
Thank you.
Thank you, Chair. Good afternoon once again, Judge.
Good afternoon, Honorable Commissioner.
I hope you're well. You need some water? You-
I will take.
Okay, you can take that.
Okay, thank you.
You're good to go now, Judge?
Yes, thank you.
Okay, thank you. I've gone through your sample writings, the 5 of them. There are decisions on law of contract, administrative law, election, succession, and criminal matter, that's murder. Your writings are competent, balanced, analytically sound, and have measured judicial temperament. You engage well with precedent, and your tone is restrained and impartial. So good job. As a PJ, you sit in the County Court Users Committee, right?
Yes.
And you also engage with other actors outside the court for purposes of administration of justice.
Yes, I do.
So how do you then balance your role as a judge when it comes to hearing and determining disputes, and you engaging with actors? And at times I know these actors would be the county government, would be the Law Society of Kenya, business community. You may want to do a prison visit, you want them to help buy soap, sugar. You have a judiciary open day, you want them to get for you water. How do you balance your role as a judge when it comes to hearing and dispensing justice without compromising the engagement with these actors?
Okay. My dealing with them will be professional. Work within the agenda that is before us, because they also have a role to play in the community. Most of the time, we rely on them for some of the activities, like for Baringo County. We have the local leaders who assist us in getting courts or having space for courts to use in areas where people cannot reach the court. So we have to work together with them, but the working will be limited to the issues that are to be dealt in the particular committee.
So,
yes.
for example, you need money for a judiciary open day. you go and engage the governor and ask the government to give you some money. It can be personal donation, for example, 100,000 shillings. And then the governor appears before your court to have a dispute adjudicated upon. It's not just for you, but also for the people around you. How do you ensure that you don't engage in a particular manner that would be perceived you either biased or not so sure on what you're doing?
I don't think it would be proper for me to engage the governor to give his personal money, because we have to be seen to be independent. Yes.
Okay. Thank you and all the best. Thank you, Chair.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
You've shared with us quite a lot about your insights on case management and performance. I don't really have much to ask you. I got from what the presentation you made earlier in response to Judge Mrima's questions. But I just want to ask, as a person who's been in the institution for over 30 years, how, because performance is the responsibility of an employee, while facilitation is the responsibility of the employer. How do you feel the employer, especially in respect to the judiciary, would better facilitate the employee so as to improve performance?
Okay, there are occasions where we've lacked resources. Maybe you want to carry out some activities like open days or sensitization. At times maybe infrastructure. I think in those areas is where we need the employer to provide the finances.
So is it just about resources, or is there any other way the employer could support better performance?
Okay, the other way would be on training. Most of our staff are rarely trained.
Mm-hmm.
So you find most of the time the people who are trained are the judicial officers and judges, but the people who work under us are never trained.
Okay.
Though as judicial officers on the ground, we try to fill in that gap and train the people who are under us, mentor them also to perform better.
Okay.
Yes.
Again, as someone who has been in the institution for quite a long time, do you feel the framework that we have for performance appraisal is good enough, or do you think it could get better? The system for performance appraisal that we are using.
I think what I could only recommend is feedback, because we get feedback after 1 year.
Feedback,
so
okay, yeah,
on our performance. So we could be getting periodically, maybe 2 months or 1 month, so that we can be able to assess ourselves and maybe strategize on how to improve on performance.
Oh,
yes.
In the High Court, you don't get monthly feedback of the performance of the station?
I am not aware of.
You personally have not seen it?
I have not seen it.
Oh, okay.
Yes.
Okay, thank you, Judge, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
You said you did a master's in public finance.
Yes.
Could you then tell us how, as a judge, you will apply the key principles of Public Finance and Management Act of 2012 in managing judicial resources?
One of the ways I would apply is to participate in budget making and ensure that money that is allocated to the station is properly used. And because I have to give an input, ask for the money, but in most cases there's no oversight on how that money is used, or the judges may not be involved in ensuring that the money has been used properly, or money is allocated to the right fortes or areas which are in need of finances.
Those are true.
I think the other issue is transparency and openness, because there is need for all stakeholders in the staff and judicial officers to be involved in the process of making the budget and also the process of how the money is being used. So they should, it should be participatory. There should be some transparency and accountability.
Okay. How do you maintain professional credibility in high pressure or politically sensitive environment?
As a judge should avoid situations which may bring conflict. Maybe in the way I relate with the people from the political field, and also make clear judgments, clear decisions, so that they can also know the position of the court. Not allow myself to be compromised. Mm-hmm. Yes.
So if a judge issues a controversial judgment that triggers intense public criticism, would you consider issuing a statement or an explanation to the public beyond the written judgment?
The judgment, in my view, the judgment should be clear. You should be able to explain what you intend to tell the people, and I should not be looking to forward to explain anything. That judgment should be clear. Okay. Yes.
Okay, I wish you all the best.
Thank you.
Thank you, Honorable CJ. Good afternoon, Judge.
Good afternoon.
A few questions from me. Please tell us, what is your understanding of sexual harassment?
My understanding is that it's unsolicited sexual behavior. Yes, and maybe, okay, in a case where a person has been shown that by the other that he is not interested in a relationship, but the person continues. Or at times, in some cases, because of whatever gain that the person wants, forced to engage in some behaviors which may not be consensual.
Okay.
Yes.
Do you know the forms in which it can happen?
It can happen during times of maybe a promotion. Somebody wants to be promoted,
No,
and
forms in which you can say one has been sexually harassed.
the forms could be in conduct. Yes. Or communication. Yes.
Any other?
I cannot recall another one now.
Okay.
Yes.
What do you understand by the term transformative leadership?
Transformative leadership is a leader who has to bring change in an institution, and is doing it by inspiring the people who are working under him or her, mentoring them to achieve the changes in the institution.
Okay.
Yes.
Given your answer, would you term yourself as a transformative leader, and if yes, why?
I am a transformative leader.
Why?
And I think I've demonstrated this in the stations that I've worked in. Maybe one example that I can give is Milimani CM Commercial. When I reported in the station, there were many things which were not in place, like the registry. There were many challenges like of case files missing. For finances, there were fake receipts. So, and then there were also delays in hearing cases and judgments. So together with my team, we worked on putting measures in place and also ensuring that the registry was operational, and also agreed on how to fast track cases so as to reduce case backlog. So in almost every station that I've worked in, what I've done is to study the situation in the court and see what I can change.
Okay.
Yes.
Would you tell me situations where you'd use one, command decision making, and second, consulting decision making two scenarios where you'd use those different decision-making
I think
approaches.
for command, if something has to be done. There's a process like we have to file returns at the end of the month. That is command. There's nothing else that you can. You cannot. There's no explanation you can give about it. There's a deadline. Yes.
Okay, and consulting decision-making?
Consulting could be other activities in the station where you need to get the views of the other members so as to know the way forward.
Okay.
Yes.
Thank you, Judge, and I wish you well.
Thank you.
Yes, Judge, I see you opted to have us public finance. Most people in law would rather keep off that area, but I can see you've gotten into it. Maybe you can tell us the types of revenues that the judiciary collects and how these are accounted for.
We have court filing fees. We also have fines. There are deposits. And there's also money that is realized from forfeitures. Yes. There's returns have to be filed by the station on monies that have been collected. And then there's also an auditor who looks at the records to confirm whether they have been, the books have been kept well.
Okay, fine. Let me leave these others. Thank you.
Okay, thank you.
Thank you, Judge. I just wanted to follow up on a question. You answered to Commissioner Rwande when you said you'd do with feedback.
Yes.
In a station, you own the data that is in the station.
Yes.
In other words, you know the number of cases that are pending in your station, do you?
Yes.
And you know the number of cases you have cleared per month.
Yes.
And you also have the previous data for the last month.
True.
So what feedback would you want?
At the end of the year, we normally get, we are assessed in different areas, not only on caseload. That is what I meant.
So now we would tell you about this information before you are assessed. Because you are assessed in other areas, readership, whether you have held court users committee, whether you have had awareness, all that. That is done externally. So how would you get feedback midterm?
My thinking was maybe we could have more than one assessment in a year.
Okay.
Yes.
More frequent.
Maybe 2 for a start.
2 for a start.
Yes.
Of course, it involves money, and budget is always a problem. But that is something you can also be able to assess yourselves, isn't it? Because you know what you have done and what you have not done.
Okay, maybe we are given parameters of assessing. I think we can try.
You can try.
Yes.
Okay. What systems have you put in place to address the issue of backlog? You have talked about it, your successes in the courts where you have worked, but you have not given the actual particulars of the systems of addressing backlog.
Okay. Through pretrial, for civil cases.
Pretrial is one.
Pretrial, yes. So that during pretrial, we are able to know whether a matter can go to ADR or it will proceed in court. If it will proceed in court,
so how do you go about that? Do you restore those trials, or are they done by a DL, or how are they done?
we list, what I do is to list them, invite the parties, we have a mention, and then we go through the process.
Okay.
Yes.
So you have a set day when you do those mentions for pre-trial?
Okay, I do not put them in one day, but I spread them.
Okay, over
Yes.
your courses?
Yes.
Okay. Which other system do you employ?
I'd already mentioned some. The issue of fast-tracking hearings.
Mm-hmm.
Yes. I think my view is that once a case has hearing has started, it should move. It should be heard with and be concluded within a very short time. So that is what I do. Once I start a hearing, the next hearing, if I am not able to conclude on that day, I give a hearing, and within a very short time, I'll have delivered a judgment.
Okay, you
Yes.
give priority to patterns.
Yes, and I also look at the old files and give them priority hearing dates.
And you have a system of bring up of
Yes.
old files.
Yes.
Okay.
Yeah.
Have you identified a common trend in your courts that can enable you perhaps identify the cases that do not take a long time and you can deal with them easily?
I identified during those mentions
You identify.
because I engage the parties and the advocates.
Okay.
Yes.
There's no other way of knowing some things that keep coming all the time?
For some cases which are simple, we give we give the mention dates,
Which are those?
like revisions.
Revisions.
Revisions, I deal with them within a very short time.
Mm-hmm.
Yeah.
Okay. Who brings revision?
We have revisions from applicants, the people from prison. They make applications to have their sentences reviewed, and at times we get the directive from you, the CJ, on
From?
we get directives from I believe it's from there are circulars that we get once in a while to revise cases in prison. But most of the ones that I deal with are the ones from individuals from prison who make applications to have their cases revised.
Is there a way you can be proactive in dealing with that
I normally do them periodically.
without having to wait for a memo or to wait for a request from the prison?
I normally deal with them periodically, so I don't wait for that list. Yes, and most of the time we also,
What do you
as a
mean
station,
periodically?
sorry,
What do you mean periodically?
we, as a station, like in Cabernet now, we have prison visit. So when we visit the prison, we talk to them, sensitize them on legal issues, and tell them which cases they can apply for revision, and then talk to the in charge to have those cases filed in court for revision. Yes.
Very well. From my interaction as a trial judge, I know in succession most of those cases can be done faster. Have you encountered that?
If they are, for succession, if they are not contested,
What is the percentage of the cases that are not contested?
okay, the ones which are not contested maybe are confirmations and most of the time adoptions. And small applications like to substitute or applications for rectifications. Those ones are move very fast.
They move very fast.
Yes.
And most succession matters are also not contested. The families have agreed.
Yes, most of them agree, but for those who don't agree, what I normally do is to refer, propose to them mediation. If they are agreeable, then I refer.
Okay,
And most
so
of them are settled through mediation.
you must have what we call hanging fruits, so that you don't keep everybody waiting at the same time.
Yes,
There
thank
are many matters which you can deal with expeditiously without people having to wait. I think that is all I needed to clarify, plus I wanted to know from you what you understand by the theory or concept of shared leadership.
I think I've not thought about it much, but my thinking is team working as a team.
Working as a team.
Yes, or
You have not heard me espouse about it?
I've seen it. Yes, I think it's working as a team or working together with other stakeholders to achieve some goal. Yes.
Okay. That one you can refresh. I
Okay,
think
thank
this brings us to the end of the interview. But before we release you, we always give the candidate the floor also to engage with us.
Okay, there is. Thank you for this. It's been an interactive session. I'm so grateful. But one thing has been in my mind. Maybe I can ask if you allow. Besides shortage of judges in the Court of Appeal, in my mind, I've been wondering whether there are other challenges that contribute to the case backlog in the Court of Appeal, apart from the shortage of judges, which the new judges should be able to address immediately.
The court works extremely well. In terms of collegiality, we've again done extremely well. The judges are very collegial. The biggest handicap is what you say, the lack of sufficient numbers, and the more hardworking judges that we get into this court will go a long way in helping Kenyans deal with the appeals that are pending in that court.
Thank you.
Thank you.
Thank you very much. Or do you have another question which you
No,
can
I
ask?
do not have any other question. Thank you.
Okay.
Yes.
Maybe I can also add, CJ, that in terms of integrity, the court is ranked very highly, and we also look forward that the judges who will join us will also be men and women of integrity.
Thank you. Thank you.
Thank you. So I take this opportunity to wish you well. When we complete the exercise, we will get in touch with you. But meanwhile, we hope that you can continue working hand and serving the people of Kabarnet.
Thank you. Thank you, Honorable CJ.
All the best. You are released.
Thank you.
You can take your writing pad
Okay.
and your water.
Thank you.